Thank you for conducting this timely and important hearing. I had prepared testimony about anonymous reporting, but it's in the record, and I am not going to read it. Chairman Hevesy is the sponsor of that bill. I know he understands the importance of moving from anonymous to confidential reporting. And frankly, you all have more stamina than I do. And I need, I think, the adrenaline of speaking extemporaneously. So instead of reading my testimony, I'd like to comment on two of the issues that have come up repeatedly and that you've asked, I think, really important questions about. And we'll test whether my adrenaline is up to the job. But I think no one could have sat here today and not understood that the single loudest, clearest message from the communities who are directly impacted by children's services is that the very first, most basic step toward addressing the racial injustice of the system is telling families their rights. Nothing could be more basic than that. Now, Chairman Hevesy, you raised, I think, a very important question, and I know it's a question that others have as well. And I do want to make sure, I want to make you aware that following conversations in which you had previously raised some of these concerns, PLAN, the Parent Legislative Action Network, has worked with Assembly Member Walker to add some language to the Miranda bill, which would clarify what was always intended, which is that the Miranda bill does not create new rights, as has been said repeatedly here today, and it does not endanger children. And so what the bill says with the new language, and this is also true in the City Council, where analogous Miranda legislation is pending.
But smaller in scope, right? The council bills?
Only smaller in the sense that it applies only to New York City. The substantive rights are actually exactly the same. They've made some changes since it was first introduced. It is now perfectly analogous in terms of the substantive rights, and also in terms of clarifying the point that I know it's key to you to address, which is we are telling people the rights they have, and we are making explicit in the statute that, of course, the child protective worker does not need to stop and give those rights if there is an emergency situation underway. I want to take us back to what Joyce McMillan said at the very outset here, which is that New York law is clear, that there are 3 situations in which an ACS worker is allowed into your home, just as there are with law enforcement. They can ask to come in, and you can invite them into your home. That's always allowed. They can seek a court order. A police officer can go get a warrant. A caseworker can go to a family court judge and say, we have reasonable cause to believe there is a child's life or health at imminent risk. And they can get a court order, and the Family Court Act is very clear about that.
Or exigent circumstances.
And the third situation is exigent circumstances. And again, that has to be based, this is not written into the statute, but it is clear from the case law that that also entails reasonable cause to believe that there's imminent risk to a child's life or health. That's clear in New York state law, and the United States Constitution, Fourth Amendment, applies to child protective workers just as like it does to the police. They need a court order or exigent circumstances. And all the Miranda legislation is asking to do is to say, if there are not exigent circumstances, you need to tell people their rights before you ask to come into their home.
Okay, then let me jump in. So, and that's the exact point where I believe we're going to run into a lot of, I may be wrong. By the way, I may be misreading my colleagues. It's not the first time I've misread, but I believe that it's the timing that is the issue. It's not the rights. I have no problem with the rights. You're damn right that these parents should have their rights, particularly when they're put into a potentially coercive situation where they have like zero power and no understanding of the system they're going up against. I'm for their rights. So the question for me is, does require, and so I think this is the crux of the issue, and I don't have the answer, but I think the crux of the issue is, does requiring the rights to be given while the CPS worker is outside of the house in any way endanger the kid in the house? Because now we've just, part of the rights are, hey, you can't come in. We don't have to let you in, right? So
that's right.
Right, okay.
That's right.
Okay, so does that put the kid who's in the house at risk? That's the only thing I'm interested in. But Joyce, we'll get back to you, but Like Chris, go.
So the Fourth Amendment says that the government cannot come in and search your home unless they have the reasonable basis. They don't get to come in and then after the fact say they have found the reasonable basis, right? If they did that in a criminal scenario, we would say they couldn't use that evidence against you. If they have reasonable cause before they go to the house, then they are allowed to come in. But if they do not have reasonable cause, they do not have a right to demand entry. That is the law today. And the scary thing, the really disturbing thing, is that ACS doesn't seem to understand that. I mean, police officers at least understand when they're violating your rights. I honestly think that many child protective workers are trained to demand entry when they don't have a right to. If there is a report saying a child has missed too much school, that is not a reasonable basis to demand entry to their home. That's a basis to go to a judge and say, we need a court order. An anonymous report alleging that a child had dirty clothes or that there isn't enough food in the home. Those are not exigent circumstances. You do not get to demand entry to find evidence to justify the government intrusion. That's just a mischaracterization of what the law is today. There are times when they have reasonable cause. Oftentimes, they have time to go seek the order, just as police seek warrants most of the time. ACS goes for court orders in a handful of cases.
That's really helpful. So we're only talking about the cases where there isn't a reasonable cause.
Exactly.
So any reasonable cause, exigent circumstances, a court order, or they can go in.
It has to be, the exigent circumstance is actually tied to the reasonable cause. That is, the reasonable cause has to be of a serious enough nature. Miss school, you're going to court first. Dirty clothes, you're going to court first.
But kid yelling and screaming and, yes.
Just like a police officer can break down a door if he hears someone yelling.
So what you're telling me is the fear that I have had about the timing of the issue making it more dangerous for the kid is unfounded because the kid can still be taken care of in exigent circumstances. This is just a huge misunderstanding on my part?
I think it's a misunderstanding on a lot of people's
You have no idea
parts.
how many times a day I'm wrong, so it's okay. But
I think there's been a lot of misunderstanding, and frankly, it is you said earlier, Chairman Hevesy, that ACS has never said they don't want to give people their rights, and I think that it's a huge frustration for people in this
They never
room.
said it outright. I understand now what you're talking about by taking the position that you don't want to do it before. I understand.
Okay. And I think that the evidence you have accumulated here, there is not a witness here with firsthand experience of an investigation who has told you they were informed of their rights. I have never, in my 20 years doing this work, met a parent who was informed of their rights. It's just the very first step that we need to address. If there are more questions on that, I'm happy to answer. There's one other issue.
Before you go on, because I'm getting lawyer text, which is really fun.
I'm not the lawyer. My
No.
boss is the lawyer.
Actually, don't take the phone away. Can I have
Oh,
it?
yeah, sorry. So I want to know about being safe.
Yeah, so the objection was not about,
When? Making sure that they're safe. You want to make sure that they're safe.
yeah, of course, okay, so we're looking to make sure that the child is safe. It's not about the timing, is what you're suggesting. It's not about the timing. So because there's this misunderstanding, you're saying that this is an innocuous bill?
I think it's always innocuous to tell people their rights. In fact, I think it's a basic tenet of democratic society. I mean, I just don't understand how someone could see it as a threat to inform people of their rights.
Because, and I'll tell you why, and this is my misunderstanding, and if I'm learning here, let me learn in public. So, because I was under the impression that by giving rights to parents outside the home, which say on them, you don't have to let me in, could be, just logically, intuitively, that means, okay, if you're looking at the CPS worker, and I understand that's not the mood in this room, but if you're looking at the CPS worker as someone who's there to help kids, then that's a problem. You see, so, but the fact that this actually doesn't do anything like that, and there are exigent circumstances, and the kids can get access to, they can be protected, is a game changer for me.
Can I help Chris to help you, please?
Joyce, come on up, would you?
I need your help, Joyce. Here. Listen, the point is this, when the call comes into the state central registry, we already know what the call is in reference to. So if it is a call where we feel that the child could be at some type of imminent risk, go to the house directly and do what you need to do. If it's not, go get the court order. It's not a surprise when you get to the door.
So let me say this. I had a fundamental misunderstanding about this, and I would like to talk to you more about it offline. And by the way, again, this is Latrice Walker's bill. She is the lead. I think she's a great elected official, and I will follow her lead on that. But I didn't understand. I was conflating issues and thinking that kids were at risk when they, considered that they weren't.
Well, I look forward to talking with you further about it.